All right, hi, welcome everyone. My name is Rilus Dana from MAAT Legal. Today I'm going to go through the personal family legal session. We're going to break it down. This is the name for the first meeting that a client does, an estate planning client. So estate planning meaning they're doing it their own planning. If someone is coming regarding a probate or trust administration, we call that the administration department. So today, personal family legal session. Let's get into it. Let's start with this is a shared folder, the EP meeting. All these tools are what the MAAT Legal Attorneys get. And I had this folder open here with Mr. Estate. He's the star of the videos, Mr. Estate. Because I'm just not that original to come up with a name, a generic name. Mr. Estate's kind of stuck though. It's been around. So this is the personal inventory. Now, ideally, the clients have filled this out before the meeting. Now, I don't know what your experience has been, if your clients have filled these out or not. Sometimes they say, well, that didn't apply to me. I love that. It's one of my favorites. What, you don't have a name? That's kind of important. That applies to you. And then we want to know if if you're married, or if you have kids, that type of stuff. So sometimes you have to start filling this out with the clients. And what we'll do is we'll get on a screen share. If it's a virtual meeting, you'll get on a screen share, or if it's a real life meeting, you'll be looking at this paper with them. So, and this program on my screen is Adobe Acrobat Pro. This is an essential tool. You'll need to have Acrobat Pro so you can edit PDFs and also sign them. So it allows things to be done digitally. So in Acrobat Pro, there's some choices over here, the different kind of modes you can be in. You can create a PDF, combine files, edit PDF, export, organize, send for comments, comment, fill and sign. I don't know what a lot of those do, to be honest with you, but we're just going to do the fill and sign today. So we want to be on this fill and sign option, and you do it for yourself, because you're going to fill it and you're going to sign it as the attorney. This is how you sign the fee agreement so you can send to them electronically. Okay, so date, go through, fill it in. What is today? 4/24/2020. How did you hear about us? Okay, this is the most important question on here. Or not really, they're all important. But this is on here for not just to track our marketing, which is important, but this is the icebreaker. So the point of this meeting is to get to know the clients. You want to talk to them like they're real humans and see why they scheduled the meeting. So how did you hear about us? Sometimes that's a friend told them, or maybe they looked it up on Google, or maybe it was all of those things. And then if they looked it up on Google or whatever it was, then I like to ask, well, what did you ask your friend? What were you looking for? See if you can get to the pain point, all right? What led them to schedule the meeting. Now, this first page of the personal inventory, even if it's filled out, even if the client has already completed it all and you're looking at it together, I want to spend a lot of time on this first page first. Who they are, do they have kids? I don't want to go right to the asset information. So, a couple things about this personal inventory. It's only 2 pages. I'm really proud of that fact. That's part of the MAAT process, is we do things, we simplify things. That used to be one of our core values, but we simplified our core values down to just MEP in that spirit. 1 sound, 3 things, mindfully empowering passions. But in that spirit of keeping things short, we want to make it easy for people. So 2 pages, second page is the asset information, but when you meet with the clients, the focus is about them. You want to talk about how they heard about us, see if that sparks some conversations. Then you're going to get their name, Mr. Estate, and I like to ask, what do they do for a living? See if you can get more clues of who they are, what they do. What they like to do is even better. If you can get into some of their hobbies and passions, is great. So they're married, Mrs. Estate. If it's If they haven't filled this out, I don't get all of this information. I'll have them go back later and fill it out, or I'll at least just try to get their names. See if they're married. Are they married, divorced, or not married sometimes, but have a partner? So we want to get that status. And then children. Do they have any children? There's the one together. We'll just call him the anchor baby. There's a state junior and Mrs. Junior. So this is what I would call his, hers, and ours kids. So we want to know, do they have children, and who are the parents of their children? This is important not just for the family dynamics, but we need this information. We need to know the legal relationships to draft the legal documents. So we ask for that information, the birthday, marital status. So ask about the kids, ask if they're married. Here's the other question. When they're married, do we like their spouse? I love asking that question. Sometimes it gets a laugh. Sometimes it gets, oh man, they'll give you. Sometimes they get right into it, or they'll say, well, what do you really want to know? So again, those are the types of questions you want to ask, is you want to see how they react. I think that's kind of, I would say attorney 101, but maybe it's not obvious. So when you're meeting with clients, when you're talking to people, you want to ask a lot of questions so you can see what they're looking for and how you can help. So kids. Tell me about the kids. What do the kids do? Are they going to school? What are they studying? Get a sense of what kind of kids they are, if they're going to need any special care or anything like that. So that's page 1 of the personal inventory. So by the time you scroll here, by the time you leave to their asset information, you should have an idea of who their family is and what they define as family. Because that their blood relatives isn't always what they're closest with. It may be that they have children, but they're not in their lives at all. So sometimes they don't want to list them. We still need to know about all the kids, especially if they don't like them. Then we have to clearly disinherit them. Okay, page 2. This is divided between real estate. So we want to know the value of the real estate, the debt, who's the owner, is it a person, is it in a trust, is it an LLC, that type of stuff, retirement accounts, non-retirement accounts, life insurance, and other. And that's it, 2 pages. Okay, so they have that filled out, or you've helped them complete some of it and ask the questions to see what they're looking for. And then is where the fun begins. So we had this PFL presentation, personal family presentation plus life estate. So this is a long-running PowerPoint, and you can see the scripts to all of these videos on our YouTube channel. Right now they're on the Dana and Associates YouTube channel. We'll be in the process of moving these over to the MAAT Legal page as well. But there's, let's see, anything from, what is a durable power of attorney? Welcome back. Oops, I'm not going to actually watch it, but I'll just scroll through so you can see that it uses the same PowerPoint. And then as you're reviewing the personal inventory, every meeting is a little bit different. We try to, have a certain script, if you will, or certain road marks that we like to get to. But sometimes people want to skip ahead. They want to know, do I need a will or a trust? Or is a very common question. Or I came in to get a will. So if that's where they started out, I would bring them to about, I would talk about probate. So when someone says, okay, yeah, I want a will, I would say, have you heard of probate? Would be the transition to start talking about some of the benefits of a trust. So probate, and then I would start the show right here. So slideshow, play from current slide. What is probate? Well, here's Mrs. Estate and Mr. Estate. They own a house together. Mrs. Estate has a bank account just in her name, a life insurance policy with Mr. Estate as a beneficiary. When she passes away, Mr. Estate collects the life insurance, the house, because it was joint tenants with right of survivorship, but the bank account is still in her name, still in the name of Mrs. Estate. So how does he collect that? So we look at her will, the last will and testament, and we see that it names Mr. Estate as a personal representative. That's what we use this green hat for the fiduciary. Beneficiary is also Mr. Estate. But we need the probate court. We need Uncle Sam. We need the government to activate his powers as a personal representative. So probate, there's a lot of steps involved, and it takes time. So you have to notify all the creditors and potential creditors by posting in the newspaper, and then you have to wait 4 months. So regardless, there's this built-in waiting period, so it takes time. So that's why people generally like to avoid probate. So after you go through all of those steps, then you can collect the bank account. Okay, so that's a transition to, okay, so how do we avoid probate? Let's see. I'm recording my screen, so I can't hit stop. The little touch bar on the Mac allows you to stop the show. I guess I'll hit escape or something. End show. There we go. Another way to do it. And then I'll go back and forth between, because I don't want to have them just lost in the animation. I want to make sure that they're having a custom experience, so whatever questions they had. Now, if it's a single person I'm meeting with, then I would show how the single trust works. Or if it's a married couple, I'll show how the continuation trust works. So the point of the personal family legal session, you want to get to know the client, see what they're looking for, and see if we're a good fit to do business. So the first part of the meeting is built up, you want to gain their trust, see what they're looking for, and then after you get an idea of what you recommend for them, like if you know they're a good candidate for a trust package, then you want to quote fees pretty quick, because you don't want to start answering a bunch of what if questions unless this is a paying client, and also you want to keep them organized in how things and how to design their plan. So this person, let's say I showed them probate, they say, okay, a trust might be a good idea. Then I would transition to say, well, let me show you how a continuation trust would work if this is a married couple. So again, I get back into the show, play from current slide. So Mr. and Mrs. Estate, so they have a house, a bank account, they each have retirement accounts, and they each have life insurance policies. They create a trust, which is a legal contract that names the beneficiaries and the conditions. It also designates the successor trustee, so who will be in charge when they can't manage it. Now, there'll be the trustors, the trustees, and the beneficiaries of the trust. So we use the trustor, this briefcase showing the boss as the signal came up for that. Trustee, that fiduciary hat, then the beneficiaries. The trust is revocable with that unlock, meaning they can make changes to it. So they'll transfer their house into the trust, their bank account. The retirement accounts stay outside of the trust and will name beneficiaries. The life insurance accounts will also name beneficiaries. All right, so Mr. Estate passes away. Mrs. Estate, that's her life insurance. On his, we look to see who the beneficiary is, which is the trust. So that'll be added to the trust bank account. Mrs. Estate, she's still the trustor, the trustee, and the beneficiary. And the trust is still revocable. So she's the boss as the trustor. She has the power to change it and do whatever she wants. The IRA rolls over, becomes her IRA. All right, time goes on, Mrs. Estate, her health declines. So a successor trustee is appointed to manage the trust for her benefit. So that's another one of the advantages of the trust. Sometimes you'll have people that say, well, I don't need a trust. I was at a cocktail party with my friends and they said all I need was a beneficiary deed or a beneficiary designation. Yeah, true, that's another way to avoid probate, but part of the value of the trust is right here. So Mrs. Estate, she got dementia or Alzheimer's or something like that. Or I have a lot of clients, they do this voluntarily. They say, you know what, I'm sick of managing everything myself. I want someone to help me manage everything and just make sure there's money in my accounts so I can do what I want. So we can do that with a trust. All right, when she passes away, the trust becomes irrevocable. We look to see who the beneficiaries are. The IRAs, those are taxable, the proceeds from that, income tax, and that'll be transferred to the beneficiaries. Life insurance is income tax free. We recommend that you name the trust as the beneficiary. The age restrictions, so in this case, the age restrictions are 1/3 at 20, half the trust at 25, and the balance at age 30. So we look to see the ages of the beneficiaries. They decide to sell the house in the situation. So the oldest child, who's also the trustee, will get his share outright since he's over 30. Now the other two, so let's go with the 21-year-old. A trust will be set up for him. He'll get part of his share in trust and the 1/3 distribution directly. The 18-year-old, all of her share gets held in trust for her benefit. So that's how the trust works. And then what we'll do, then I'll go in and quote the fee. So the client says, yeah, that's, how much does that cost? That usually comes up naturally, or sometimes it comes up earlier. So we'll look at the welcome packet. So this is the estate welcome packet. Security's been updated, great. So it's just the asset welcome packet I'm looking at, the name actually. But this, so you'll save this welcome packet. This will be saved for you before the client meeting, or this is what you'll save with your client's name in there specifically for the meeting. So they ask, what does it cost? So the transition I make, I'll have this up. I'll go back, from the PowerPoint. What does it cost? Okay, so what it costs for you today, almost free, practically nothing. No, don't say that. Maybe not. First, say what it includes. So timeline. So here's what it includes. Today is what we call the personal family legal session. What we'll do today, if we decide we're a good fit, we'll sign the fee agreement and we'll get drafting instructions of how you want to design your plan. Actually, you'll sign the fee agreement after today's meeting, and then you'll review the drafting instructions. Then you'll approve all the drafting instructions and schedule the signing meeting at the time you approve the drafting instructions. I also would have the drafting instructions up too. Let's see, drafting and approval. All right, so here's the drafting instructions. So what we'll do, we'll fill these out together if we decide we want to work together, and then you'll approve everything. The next meeting will be a signing meeting, which is where we'll sign everything. We'll meet either virtually or in person to review everything, and then you'll meet with a notary and a witness to sign. The very final meeting is what we call the trust asset coordination session. This is where you meet with an attorney to make sure your trust is funded. They'll give you personal recommendations on how to fund your trust, and they'll show you all of the features of your trust. Now, I've been these virtual meetings, I've been liking having a binder with me, just handy, so I can start showing them the features, and I make my joke. I make the same jokes every time, and I laugh every time, so that's why I make them. But I say it's my Vanna White moment. I get to show off all the features of the binder and show everything that they get, but more importantly, to make sure that they know how their plan works and they utilize it. So that's the trust asset coordination session. So to do all of those things, the trust package is, okay, so fee agreement, let's talk about this. All right, so now it's on the screen, the fee agreement. And a lot of thought has gone into this document as well. This is a sales tool. This is definitely a sales tool. So it's important that you communicate what you're providing for the client and also clear fees, so it makes it easy for them to choose. So what I like to do, I like to let them see all of these fees, and you can kind of take their temperature. You can see if they're freaking out, they go, oh my gosh, $3,000, or some people go, oh, that's not bad. So boom, there you go. So that kind of gauges what your fee quote will be, but sit it out there, and then you want to start explaining what the package includes, and say, okay, so first, we've been talking about the trust a lot, but it also includes a will, and let's back up even more. Now, what you're hiring us for is a custom plan designed by an attorney. Now, we're going to talk about the different documents, but these are the byproduct of our service. What you're paying for is for us to guide you through the process. So we're going to do a last will and testament, healthcare power of attorney, which includes the mental health care provision, living will, financial power of attorney, which is a durable power of attorney, and the trust package includes all of that, plus revocable living trust, digital asset language. I haven't talked about that yet, but digital assets is your information that's being stored electronically. That's what digital assets are. So our plans provide a way that makes sure if you're storing things by email and getting online statements, we make sure that your family has a way to get to that. So there's general language where they can request an inventory. We have a digital asset trust that allows you to make more specific requests over things like email, iCloud accounts, and other photo and video accounts that you might have. And then a digital vault membership. So this digital vault membership, it gives you a place to store everything electronically. So then I'll show them our website. So this is the login to the digital vault here. So after you create your account, you'll be able to log in to your secure information there, and you can decide who can access that and when they can access it. The trust asset coordination session, what we talked about, and then one Arizona deed. So to do all of those things would be $3,000 for a married couple. To get started, we just need a deposit of half to get started, and the rest is due at the signing meeting. Boom, you see if they want to work, if they want to go forward, and they say, oh, that's more than I thought. Okay, all right, have a great day. Or depending on what their needs are, they might want more of a premium plan, or they might have other needs as well. So quote the fee. If you come to an agreement on what a fee is, then you'll go through, you'll sign the fee agreement. There's also a couple conflict waivers that I'll point out. This first one is for partners. So for married couples, we want to disclose that there's no individual attorney-client relationship, that everything any partner shares, we also have to disclose to the other partner. Conflict waiver for MAAT companies. This discloses other interests that I have. So I have interest in MAAT 1, MAAT Legal, and MAAT Financial. So if you have needs, real estate or financial, and you ask for a recommendation, I may share in fees if I make a recommendation. No obligation, it's just disclosing that I'm in those businesses. So the clients will initial that. California people have to do some more stuff. Of course, there's always more in California. And then get in, so $3,000, deposit $1,500, remainder due, signing meeting, trust package, and let's see, how do we sign? Go ahead, fill and sign. There we go, hit that sign button. In Acrobat, sign it, boom, date it. All right, if they don't agree to a fee at that point, that's where you leave it. So if you would like our help, here's how we can get started. I'm gonna go ahead and email you this welcome letter that has this fee agreement, and you can decide if you wanna work with us. Okay, so now you quoted a fee, they've agreed to a fee, they've paid their deposit. Now it's time to start designing their specific plan. So 2 ways we design the plan. So here's the drafting instructions. This is the words. This is going to be the official instructions, but here's the experience. So I like to talk about, I like to use the flow chart and talk about their personal plan, talk about their assets that they have, and talk about how they should be set up. So we have these little tools or little houses over here, and different people we can grab, different types of assets depending on what their plan is. Usually, I like to start moving everything in for them as part of the demo. And say, all right, so you guys have the house, bank account, you have life insurance, IRA. We'll talk about who the beneficiary should be. Oops, I'm kind of messing up. So usually the beneficiary is going to be their trust. For the life insurance, for the IRA, usually it's going to be their spouse, but sometimes we end up naming maybe someone else as the beneficiary. House will be in trust, bank account. I like to show how one person passes, the surviving spouse will still have the house and bank account in the trust. The life insurance gets added to the bank account inside of the trust, which is why I like to name the trust as the beneficiary. If people name their spouse individually, what I've seen happen a lot is they don't put it back into the trust, and the surviving spouse passes away, and the kids have to do a probate to collect that life insurance, or the proceeds of it. So we'll add that to the bank account. IRAs. Now sometimes, depending on the ages of the kids, we'll want, if the kids are adults, 30s, 20s, responsible, usually I'll recommend naming the kids individually as the beneficiaries of the retirement accounts, like IRAs, so that way they can defer the income tax longer. With the new Secure Act, they can only stretch it out 10 years now, but that's still the best way to minimize income tax by naming the kids directly, or adult beneficiaries. If it's minor children, then we need to name the trust. We want it to go to the kids, but we want it to be managed for their benefit. So we'll name the trust, and the successor trustee can manage the proceeds for their benefit. All right, now however we design their plan, this diagram, we'll do a screen share. Shift-Command-4 is a shortcut, or a screenshot. So boom, Shift-Command-4, take a screenshot here, and then go back into their welcome letter. And this blank page here, what is this blank page for? Well, this is where they get their own custom plan. So we're going to go into Edit PDF, Add Image, Recents, and then it's the screenshot I just took. Paste that right in there. Isn't that beautiful? Their own custom plan, designed for them. And this is always my best notes, or some of my favorite notes. You can lay out how the plan's going to work, look at it in one place, and see how it goes. So design the plan big picture, and then get into the drafting instructions. So full legal name of the trustor, Mr. Estate the third, I like to get full legal names. Mr. Middle Estate. Name of trust. What do we want to name the trust? So we'll decide on a name. Something short like estate family trust or estate trust. But we'll choose the name right then. Or if it's a restatement, if they already have an existing trust and we want to change the terms of it, we'll put the name that the trust is already titled, what it's already called, and we would indicate that it is a restatement. Now these drafting instructions will be changing as our software is ready for development. It's going to look very similar to this, but it'll actually be a web form. Successor trustees, so usually the spouse is the first successor or usually it's each other is assumed for married couples, and then we name someone else. Maybe it's the kid or an uncle or trust company. And then if they filled out their personal inventory, which is really nice, you can copy and paste. So copy the drafting instructions and paste. This is especially helpful if it's difficult names, long names, spellings, like some of the Indian names I have a challenge with. So copy and paste. Distribution, specific gifts, or making any specific gifts off the top, then the residue. What type of restrictions is it going to go out in? The most common and what's included with a lot of legal benefit plans like Hyatt Legal is an age restriction trust. So when the beneficiaries receive it. Generation skipping trust. This is what we call the dynasty trust if they want to keep the inheritance protected for the children. Special needs trust. Someone on disability or benefits, any public benefits that we don't want to disrupt, we can do a special needs trust, or a pet trust. Did a really awesome pet trust recently. We gave $500,000 to a cat. So I have a really good format and template where we name a separate trustee over the money for the pets, and then a caregiver for the pets. And then what we did for this last lady is every year the pets went without incident, the caregiver got a bonus from the pet trust. So pretty cool stuff. Hook up those animals. Even though I don't actually have pets of my own, but I think it's cool to hook them up, especially when they're going to get a substantial gift. Digital asset trust. So this is something unique to us, unique to the MAAT Legal. So at a minimum, we recommend that everyone lists their email accounts so that you give the trustee the ability to request a list of emails, not the actual content. They can't read the messages in the email accounts, but they can just get a list of the emails. So we just say, estate at iCloud.com or whatever it is, list any email accounts. Other digital assets. So if they want to make requests on other digital assets, here's some of the things that we're doing. You'll see in the other videos, you'll see actually the template for the digital asset trust, but we're doing like iCloud accounts, Google Photos, Dropbox, things like that. And the choices that we can do, usually we say that we copy to spouse and to children. So that's usually the request we make, copy to the spouse if they're married or to their children. Last will and testament, personal representatives, who they want. Sometimes it's the same as a personal representative or the same as the trustees, so you could just put same as trustees if that was the case. Or actually it would be better if you copied and pasted those over. When it's the software, it should repopulate those. There'll be an option where it'll pull that information in, but we'll need all the fields complete for the software to draft. Personal property, this is the order of the personal property. So usually we go, like number 1 is everything to their spouse. Second, the personal property will go to according to a list which is or may be prepared by them. And then third would be for the children. So that's a pretty common order that we do for personal property. That way, if they want to designate any items, they can do so on the list. I don't like to get into personal property and dealing with it. Cars are personal property. If they have a lot of value, I'll put them in the trust. The other day, I was meeting with a client, and he asked about cars, and I said, well, I usually don't worry about them. And he's like, well, did you see the value of the car? And I looked back on the personal inventory, and it was like $1 million Ferrari. And I was like, all right, no, I did not see it. So that is a different story. And then his wife was asking, well, at what level do you start worrying about cars? And I said, well, if they're over 100,000 or if they're appreciating, then we might start worrying about it. And then she started telling me about like the other cars that he had. So, but usually I don't worry about personal property. I don't like to get into it. Guardians for minor children. So, who would be their guardians? My recommendations, I like a different guardian than the trustee, if possible. I like to separate who's going to physically take care of the kids with who's going to manage the money as the trustee. It's not always possible for people. Sometimes the best person to raise their kids is also the best person to manage their money. This space here is just if you need to leave any extra notes for us drafting. Durable power of attorney. So usually the spouse is the first power, and then that power is either immediate or springing. So like if they name their friend, they would probably name them as a springing. Springing means that it's not effective unless two doctors say that they're unable to handle their own affairs. So that's usually our recommendation, that they make it springing to a person other than a spouse. They give a spouse the immediate power. Some clients, though, they maybe like elderly clients, or if they already have some health issues or whatever it may be, they might want to name another person the immediate power, just as long as they understand that they have the choice to make that effective, either immediate or upon their disability. Healthcare power of attorney. So who are going to be the agents for the healthcare power of attorney? And then the deed. So the address of the deed. So the trust package includes one deed, transferring their primary residence into the trust. They may have other deeds as well, other properties that need to be transferred, or might be going into an LLC or something like that. So that's where you would leave notes down here, more detailed instructions where it's going. All right, so this is the drafting instructions that you complete with the client. So after you finish completing the drafting instructions, pop back into this welcome letter. Oh, digital asset inventory and checklist. We didn't get into that. So I'll let clients know. So if they ask questions about digital assets, or when you're drafting, when you're getting the instructions for the digital asset trust, you want to let them know that they're going to get this digital asset inventory and checklist as part of their welcome packet. So they can inventory their digital assets. 2 is check to see if they have an online tool. So what that is, like Facebook has legacy settings. They have a way where you can transfer your account. If a company has that has the highest priority. For accounts that lack an adequate online tool, you can use the digital asset trust. Lack an adequate online tool, so an example of that, Google, you can name an inactive account manager. But I didn't want to name my 13-year-old son as my YouTube and Gmail inactive account manager, so I named my digital asset trust. The last choice is consider sharing login credentials if not prohibited. So certain accounts, I had a client, he had a bunch of information on, I think it was Ancestry.com or one of those sites. I told him to go through these steps, and he actually, that's when we were developing this tool, this form. He went through those steps, and what they told him is that he could share his password and login information as a way to share all of his data. At this time, so you're going to let the client know that they'll be receiving this welcome packet, and their job is to sign it. They can sign it electronically. It'll be mailed in our office. It comes from Megan. So I let them know who exactly it's coming from. You may be sending this to them yourself, but through Adobe Acrobat, that's how we request the signatures. I like my paralegal to send it out so she can track when they sign this. So if you're doing that yourself, just let them know who's going to be sending it out, and let them know they'll need to initial the conflict waivers, sign the fee agreement, and this timeline. This is their roadmap of what's next. So this tells them what the next steps are. So sign the fee agreement, review the drafting instructions. We send the drafting instructions out in 1 week. I decided to do it 1 week later because I like a little time for it to digest. We could go really fast. I could draft the whole plan, have it ready to sign. We could go really fast, but we want it to sit well, is what I say. And I don't want them to sign everything once and then say, ooh, actually I want to change it. That's actually not what I want. So 1 week later is when the drafting instructions come. Their job will be to approve the drafting instructions and then schedule the signing meeting. At the signing meeting, we'll review everything together, and then after that, we'll fund the trust. So I just review the next steps. So next steps, sign the fee agreement and approve the drafting instructions when they get there. It's a pleasure meeting you. Have a great day. Sign off. End of the personal family legal session. Okay, so you just finished the personal family legal session. The client has engaged. They paid their deposit. Here's what you do next. So next you're going to send an email to reports, which is everyone on the team. There's just a shortcut I have as reports. That's for everyone. You can do that, reports. We'll add you to that list, Anna. Subject, what you do the client's name. So you go, Mr. Estate dash either engaged, if they engaged, which they did on this meeting, or if they didn't hire us, you would just put, you'd say meeting dash no engagement. So the subject tells what happened in that meeting. Because a lot of times I'll look at emails, I get a ton of emails, so I want to know, did they engage, did they not engage? And then you'll start the list of the email, or the body of it. I met with Mr. and Mrs. Estate virtually, or it'd be whatever office we're in. In the Mesa office, Scottsdale office, Chandler office, Encinitas, wherever it's at, wherever the meeting was located. Send email. Heading should include client name and engaged or not engaged. Location of meeting, source of client, notes about client, all offers and fee quotes, service engaged for, fee details. Sometimes they don't hire us. So it'd be I met with Mr. Estate in the Scottsdale office, quoted $2,500 for a married trust package, no engagement. Mm-hmm. So just the full report. Or maybe met with Mr. and Mrs. Estate, Scottsdale office, quoted $5,000 for a trust package with a dynasty trust and LLC. They engaged for a trust package for $3,000. Because there might be more quotes than what they actually engaged for, but I want to know everything that was quoted, everything that was offered.
Oh, okay, I see.
So, and then you're going to set the task in Clio. All right, let's go back. Let's finish this email. So, met with Mr. Estate, Mrs. Estate virtually. They found us through the internet by doing a Google search for the best estate attorney. Some clues there, to help our marketing people. What was it that they found us? Mm-hmm. This report also this is the notes for the clients that everyone sees too. So any other types of details, Mr. estate, is an avid skier and mountain climber, and was actually climbing Everest next week. Whatever it is, whatever little details, so that way the next time you see this client or someone else sees them, someone else on the team, they can go, oh, hey, Mr. Mountain Climber, or whatever things are unique to them. Climbing Everest next week. They engage for trust package for $3,000 and paid $1,500 by card, check, whatever the source was, however they paid, is what we want to know. All offers fee quote service and engage for fee details. Yeah, so amount of deposit, how it's paid, remainder due. Okay, then what I would do, if this were real life, I would copy that. I would hit send, so it sends it to everyone. And then I would go into Clio. Where's Clio? Here's Clio. Now, if this was a meeting that we just had, you click on the client. I go to the calendar is how I find it, and then I click on the actual client matter. And then you go into this notes section. This is a different client. And you do new note and then paste. I paste the notes right into there, and the subject would be either engagement or it's meeting, no engagement. So set the note. We're going to cancel that though. Cancel. And then task. So here the task is set in Clio. So if they engaged, then you'll set these tasks. You're going to tell Megan to send the welcome letter, and that's going to be due immediately. And it's already completed by the attorney. So the welcome letter it should be completed by the attorney, and then you hit save as, save it in the Google Drive for that client. Mm-hmm. Send drafting instructions. So the task is you're telling Megan to send the drafting instructions, and you'll make it due in 7 calendar days. Mm-hmm. So 7 calendar days after the meeting. And then you'll set a task to draft for Megan, which is due 8 calendar days after the meeting. Mm-hmm. Billing task for Riley, which is due immediately. And then you tell her what the specific engagements are. So if they didn't engage, then you're going to schedule 2 follow-up tasks for Courtney. So the first follow-up will be 7 days after. Tell them to call, email, or text, or unless they have a preferred preference. We need to start asking for a preferred method of communication, mm-hmm. or if not, we want them to make contact all those ways. So the first should include a link or a reference in the voicemail to what we recommended. Mm-hmm. So if we recommended a continuation trust, you could put the link in there to from the YouTube channel, mm-hmm. from that appropriate video. So like Courtney, in 1 week, send them the video about the continuation trust and ask them if they want to proceed. 2, the second task is not engaged, send a second follow-up task. That could be a custom follow-up from the attorney, or if no interest, to close the matter. So I want the attorneys to decide how the follow-up should be, mm-hmm. and to set the task into Clio. Mm-hmm. Now sometimes I've had some meetings where I don't set any follow-up task at all because it's just not a good fit. You can tell after the first meeting what they're looking for is actually not something we provide, or they're not willing to pay our fees. So it's just no tasks, it's just see you later. Now even if there's no task, anyone that comes in, we have their email, so they'll get regular emails from us about about every month or sometimes every other month. So they still get some communications from us, so they might come back later. But if they're not interested, we don't want to bug them. But if they are trying to get their estate plan done, we want to help them with that. We want to help them check that off their list and also get the business for us as well. So that's the reports, and then we'll work with you and Cleo to set the task. So you just add a task, task name, like the billing. So I would paste it straight from the email or say, what they engaged for, what the fees were, and you task that to Riley. So Riley does all of our, she's the bookkeeper, does all the accounting.
Okay.
And then Megan, tell her to do the drafting. So for Megan, due date, we change the due date on those. So that's when we make the 7 calendar days or the 8 calendar days. And then you save each task. You can just save and add another. So add like the 4 tasks, and then you're done as the attorney. So met with the client. They've hired us. You report to everyone. So that lets everyone know that they've hired us, what the instructions are, and this moves. I call it the machine. We're always refining the machine, the processes. So this moves through the machine. And that's it. So that's the end of the personal family legal session. So that's the end of the attorney role. Thanks for joining us.